within the bacteria protective part, but now we're expanding.
welcome, and thank you for joining us for the public scoping meeting on variance policies. My name is Nick Martirano. Excuse me one second. Thanks again for attending the public scoping meeting on the water quality standards variances. My name is Nick Martirano. I'm the unit chief for the water quality assessment unit. A little bit of housekeeping. If an alarm does go off, please notice the two exits. We would evacuate the building. If an alarm did go off, go down the stairs, out the front door here, and across the way to Cesar Chavez Park is generally where we would coordinate before being given the all clear to re-enter. So in the case that happens, that's where we will go. Also, if you could all please put your cell phones on silence. And if you cannot use the stairs, you will be directed to protective vestibule inside the stairwell. So just let us know if that's the case. And also, before I let Stephanie Rose get started, I wanted to kind of give a little context for the meeting. While this was identified as a scoping meeting, it really is a meeting in an abundance of caution. We had previously scoped a variance being specific to bacteria back in 2015. In that interim period, the EPA established some new federal regulations in the CFR in section 131.14, and we decided that we would rather identify that new regulation and the requirements outlined therein as part of the ocean plan and the inland surface water for enclosed bays and estuaries, because there is a lack of identification of a variance in any other statewide plan or policy. We're not establishing or authorizing any sort of extra action. The option would exist whether we did anything today or otherwise, but because a variance or what a variance is not identified in any other existing plan, we thought it important to point to it, outline what this, kind of summarize what the federal regs say, and allow that to be pointed to in the case that a regional water board or state water board wanted to utilize that option as part of the bacteria or any other sort of standards related action. So while we thought it important to let you all know for clarity and consistency, it's not technically required by CEQA. We just thought it was important to let you guys all know what was going on and how we were changing from previously scoped to what we're doing now. Michael Jurdy will have use the microphone, so if you have a question, feel free to raise your hand. Also, please sign in the back of the room if you haven't already. There are speaker cards too if you would like to fill those out. But otherwise, if there's no other questions or anything to add, we'll hand it over to Stephanie here. Thanks.
I'm Stephanie Rose of the Inland Planning Standards and Implementation Unit of the State Board. And this is a public scoping meeting on water quality standards variance policy. The purpose of this meeting is to provide a forum to consult with the public and on a proposal to include a reference to the federal water quality standards variance referred to as the variance policy. We want to seek input from public agencies and members of the public on the range of any projected actions, alternatives, reasonable, foreseeable methods of compliance, significant impacts to be analyzed, cumulative impacts, if any, and mitigation measures. The scoping meeting is where we seek input on the environmental the environmental effects of the policy. I'll give you a short little history, which I think Nick went over a little bit, but the bacteria variance was initially presented as part of the overall REC 1 bacteria objectives project at scoping meetings in January and February of 2015, and we scoped it for just bacteria. But now we're proposing to insert in the statewide water quality control plan that the water boards may adopt water quality standards variances in accordance with existing federal regulations, 40 CFR sections 131.30 and 131.14. Currently, with the exception of the Central Valley, the regional water quality control boards in California have not adopted general variance policies. There is a mechanism for establishing compliance exceptions for priority pollutants within the state implementation policy, but it is limited in scope and applicability and application. To identify and define a consistent statewide mechanism for establishing a water quality standards variance within the water quality control plans for the inland surface waters, enclosed bays and estuaries, which we refer to as the SWRCB, is our goal of this meeting and of our plan project. It's a non-regulatory process. We simply would identify in a state plan that federal law authorizes state to adopt variances in accordance with the requirements contained in 40 CFR section 130.14. 40 CFR section 131.0 defines water quality standards variance as a time-limited designated use and criterion for a specific pollutant or pollutants or a water quality parameter that reflects the highest attainable conditions during the term of the water quality standards variance. Water quality standards variances are subject to the provisions of 40 CFR Part 131.14. The provisions note the applicability requirements for submission to US EPA and how water quality standards variances are implemented within MPDS permits. The variance applicabilities, they're adopted for specific permittees and or water body segments. The state must retain the underlying designated use and criterion addressed by the variance unless the state adopts and US EPA approves a designated use and a criterion revision. They're applicable to MPDS permits and 401 water quality certifications. And the standards must not be achievable by implementing technology-based effluent limits. Discharge specific variances, they reflect the highest attainable condition during the specified time period. Technology-based limits and all other water quality standards apply. Pollutant minimization program is required and must be adopted by the Water Board and subject to public review. And they must be reviewed and approved by US EPA. Water body specific variances have the same requirements as for discharges, except that they express the expression of the highest attainable condition as interim use and criterion, and the identification and documentation of best management practices for non-point source control that could be implemented. Supporting documentation. For justification of adopting the variance for Clean Water Act 101A2 uses, at least one of the 6 factors listed in 40 CFR 131G, or to facilitate restoration or reconfiguration activities. And the 101A2 uses are water quality, which provides for the protection and propagation of fish, shellfish, and wildlife, and provides for recreation in and on waters. For non-101A2 uses, demonstration that the use and value was considered. The justification for the term is only as long as necessary to achieve the highest attainable condition. In our staff report, at the present time, we are proposing 2 alternatives. That the no action alternative, which is status quo, and the water boards would continue to adopt variances in accordance with 40 CFR sections 131.14, but there would be no clear identification of this option within a statewide plan. The other option, which we at this point are proposing to adopt, is include a variance policy in a statewide plan which identifies that water boards may adopt a variance based on 40 CFR 131.14. Reasonable means of compliance. Individual variances could analyze project alternatives and reasonable methods of compliance as part of the individual variances would analyze project alternatives and reasonable methods of compliance as part of the environmental analysis conducted during the development of the variance. They're subject to public participation consistent with state and federal law and require water board adoption and US EPA approval. Impacts and mitigation. Impacts are thought to be none because the water quality standards variance maintain the highest attainable use and all standards will be continued to apply while progress is made towards achieving the specific standard at issue. Written comments will be accepted until noon on February 3rd, 2007, and should be addressed to Jeannie Townsend, Clerk of the Water Board, State Water Resources Control Board, 101 I Street, 24th floor, Sacramento, California, 95814. Comments may be submitted by email and should be sent to commentletters@waterboard.ca.gov. They must be less than 15 megabytes in total size, or you can fax them at 916-341-5620. And please note in the subject line, comment letters, statewide variance provisions, scoping comments, so they're clearly identifiable. Presently, our timeline for adopting a variance policy is consistent with, will be consistent with the bacteria objective policy, and so at this point, we're having the scoping meeting January 2017. We hope to have a draft staff report in April 2017. There'll be a public comment period from April through June 2017, staff public workshop in April 2017, a public hearing in May of 2017, comment response June through August of 2017, and board adoption in September 2017. Here are a list of applicable websites where you can find more information, and contacts are either Michael Jurdy in regards to marine waters and myself, Stephanie Rose, in regards to freshwater.
Great, thanks, Stephanie. So that concludes the basic overview and presentation. Are there any specific comments or questions anybody has?
Does this apply to the ocean plan?
Yeah, identify.
Fred Krieger. Does this apply to the ocean plan? Or
Yes,
will it apply?
It will, yes. We will be adding it to as a provision section to the ocean plan as well.
Okay, thank you.
Do you want me to stand up or? This is so wonderfully informal. Thank you. Good morning. My name is Michelle Pla, and I'm here representing the San Francisco Public Utilities Commission. I've been asked by Laura Pagano, who's the regulatory officer for the wastewater program, to be here today. And she just wanted to make sure that you understand that the San Francisco Public Utilities Commission is very much in support of this process and is very happy to see the state taking this on. We do recognize that especially for wet weather discharges, that the bacteria standard has been an issue, and this variance will help with an interruption of the use, but would never take away the use and would never take away the standard. So we're very happy about that. And so that's all I wanted to point out. And as Fred Krieger had mentioned earlier, there are some questions about implementation as to how this would work with exceptions that are coming out of basin plans. I noted your point that only the Central Valley has actual variances, but I think other basins have exceptions in their basin plans. So once we get to that point, we'd be interested in how that's going to work, and if you want to include that in any of your discussion, that would be helpful. Thank you.
So there are a couple of exceptions in basin plans for TMDLs, the reference beach anti-deg and natural source exclusion exceptions that have been adopted for bacteria in, I think it's now up to 4 basin plans. We're planning on including those particular exceptions also. That's part of the thing we scoped earlier in the bacteria amendments. So in addition to a general variance thing, and just as Nick was saying, prior to the most recent EPA reg revisions, they were sort of unclear, as shall we say, on what variances had to have in them, and they've made it very specific. And instead of saying a state, well, may adopt a variance policy, they're now very clear about what it's required. And we just want to make sure that while the state implementation plan has these wonderful things known as case-by-case exceptions, which EPA told us were variances, that we have something that we can point to under state law that says this is what a variance is. So that's what we're doing. This is, so we will be putting it in the ocean plan and in the inland surface waters plan, which then is, while non-regulatory, it will be in a state regulation pointing then to the federal regulation.
Thank you. Tess Dunn, I'm here today on behalf of the California Stormwater Quality Association. And on behalf of CASQA, we do want to support the inclusion of a variance policy within both of the plans. I think our other general comment is, you know, the Central Valley Basin Plan has included a streamlined variance with respect to salinity, and we'd like to see the same thing with respect to bacteria as part of this, so that, you know, or maybe it's being able to be addressed through an exception, but versus for bacteria, you know, not having to go under the general policy, but have something adopted as part of this process, so that EPA is already approved for the variance for bacteria, which is, you know, how the salinity, you know, streamlined process is within the Central Valley Basin Plan. So we'd like to be able to see if there's ability to have that discussion with respect to the bacteria objectives in particular.
Any other? Did you want?
Yeah. Going back to the exceptions again, the ocean plan has exceptions going back to the 1970s. And just looking at San Francisco Bay, a lot of those permits have exceptions in them. For example, a lot of the permits have exceptions to the 10-to-1 dilution prohibition, which is in Chapter 4 of the Basin Plan. So I'm not sure that that's really a water quality standard. So it would be useful when you come out with the staff report, if you would indicate what specific exceptions would fall under this variance policy. And I guess my question is, are you going to somehow include these existing exceptions, or the ones that at least are exceptions to water quality standards? I guess that's one question. The second question is, how do you deal with exceptions that, or variances that pertain to things like dilution requirements, which don't specifically target a pollutant? Not that you have to answer that now.
I would say that I think what we are proposing to add is the additional option of doing a water quality standards variance. We're not superseding any exception already outlined within either of the plans, including the ocean plan. It's just really providing another option that has a larger scope than maybe the previous options had before that, which were maybe focused on either just priority pollutants or, like you said, dilution zone identification. This is not erasing those by any means. It's just adding another option and providing a larger scope for which a water board could utilize for NPDES permitting or 401 certifications.
So the existing exceptions will just continue then?
Correct.
Those won't be impacted?
Correct.
Except they might have to be reviewed every 5 years?
Right. The standards variances, the term within the federal regulations does say that they need to be reviewed every 5 years, which is consistent with an NPDES permit cycle. You just have to review to make sure that the term is appropriate. The term can last as long as is adequately shown as needed to work towards attaining the highest attainable use and then the standard itself.
That's helpful. Stormwater and runoff generally does not comply with bacteria standards. And it's sort of unlikely that we will find a method or a BMP to provide that compliance other than total diversion. Might you consider a statewide variance for bacteria?
Well, this is an option for the regional boards to employ on a region-by-region basis.
About the state board?
That's just, do you want to take it?
Because of the requirements to do the 101 10G factors, it's pretty impracticable for us to do a general variance that would automatically apply to all waters of the state. We are including language about water boards considering high flow suspension language for bacteria, which also requires 10110G factors consideration. So we're putting in the tools, but it's really impracticable for us to make all the findings on all the waters of the state at this time. So it's a matter of practicability to be able to do that. One option, as Tess said, is trying to outline some streamlined procedures, but even there, you still have to make the findings on the individual water body basis. EPA has made that much clearer with the current regulations.
That's Rick Rasmussen, by the way, the chief of the Water Quality Assessment section in the Division of Water Quality.
Hi,
Hi.
Debbie Webster, Central Valley Clean Water Association. And again, I appreciate this. I have a question for you on just the interplay between variances and the compliance schedule policy, in that those typically are two different tools that US EPA gives. However, the compliance schedule policy doesn't cover variances. It only allows additional for new objectives or if there's a TMDL. Would the compliance schedule policy be amended, or do you see a way that the variance would then last through the portion that would include any construction compliance work? How do you see those two interplaying is the question.
Well, the variances themselves outline how to define a term for the specific variance being applied for EPA approval. So I think it has its own appliance term and associated length of time associated with it. It is supposed to be temporary, but there is no definition on how long the term should be. That has to be defined in the supporting documentation that's included within the package submitted to EPA, so that so I think that it's not subject to the current compliance schedule regulations. That's kind of its own separate entity. It's got its own compliance via the term and the definition of the term for that specific variance being, for lack of a better word, applied for EPA approval. So I think that they'll be two separate entities, two separate.
And again, Rick Rasmussen, manager of the Water Quality Standards Assessment section. So if you only needed 5 to 10 years, Debbie, and it was a point source issue, the compliance schedule policy would just generally apply because it doesn't need any EPA approval. It's really for variances are really for issues where it's a longer term issue. And yeah, we would probably take it. Yes, the current compliance schedule policy expires after 10 years after the water quality standard is adopted, but a variance could handle, that piece where you might need construction beyond 10 years if some magic happened and we were close, and you needed another 5 years for construction, the variance could handle that, because that would just, that's the whole point of a variance, is making progress towards that water quality standard, recognizing that there isn't a magic switch for that particular standard. So mercury could be an example in some places where, okay, we can't meet a mercury number here now, but the desire is there to get there. So a variance is a tool that other states have used, particularly the Great Lakes states.
So the mercury policy implementation.
Actually, a quick question, and actually just a little bit of a follow-up from Debbie's comment. It seems to me, they're both, the compliance schedule policy adoption was a standards action. A variance is a standards action. And it seems to me, as a practical matter, as a discharger, if you can meet the standard through something that you want to do through a compliance schedule, you would do so because you wouldn't require the EPA approval. If it's something like salinity and the cost is just astronomical, you would seek the variance because it's something that you wouldn't want to seek out a compliance schedule policy on, in order to meet the standards. So I think that I think it does create a new option and tool in the toolbox, which is really important for dischargers. My more direct question is, we do have a variance policy in the Central Valley that's been adopted and approved. How does this impact or change what is in the Central Valley Basin Plan? I just want to make sure it doesn't supersede it and that the Central Valley's variance policy remains as is.
It will not supersede the existing salinity multi-discharger variance policy within the Central Valley Water Board. That would remain in existence as utilizing the previous federal regulations at the time, which were more vague, so that required a lot more work on the Central Valley Water Board's side to kind of develop the procedure. No, yeah. Any other questions? I know that, yeah.
Hi, I'm Megan Fisk with the Central Sierra Environmental Resource Center, and I just have a question. Our center wasn't involved in the scoping that happened initially a few years ago in 2015, but I looked at some of those documents, and I'm wondering what of that is being included in this and being proposed. There was more specific language about bacteria in some of that documentation.
Right, so I wasn't part of that either, but previously the previous scoping was on the much larger topic of the bacteria objectives and the provisions themselves, and in addition to outlining high flow suspensions, seasonal suspensions, and other implementation tools that could be used by regional water boards, they also proposed a bacteria-specific variance at that time. At that time, EPA hadn't released the new updated regulations, which were much more detailed on how to do a variance. So that was really our only option, was to outline it and kind of get more into the detail on how we're actually going to do it, because EPA's language at that time was very vague and didn't really outline the actual provisions. So what we're doing now is, rather than keep that, we have the new regs, which are updated and outline very specifically what's required for doing a variance, regardless of the parameter, pollutant, or water body in question. So this tool could be used for bacteria, and we would expect that regional boards may use this for bacteria, but we didn't want to specify that we didn't want to leave any interpretation where it could be looked at that it's only allowed for bacteria. So we removed the bacteria-specific language to say it's for any pollutant or parameter that you wish to use it for.
So just for clarification, you're not proposing any language specific to bacteria in this process now?
Correct. Well, it's within the bacteria provisions project. So the bacteria provisions project is still going forward, and this will be added as part of that overall project. So we're adding a new section we're updating the ocean plan, outlining these new bacteria objectives, as well as the inland surface waters, enclosed bays and estuaries, with establishing REC 1 objectives consistent statewide. As part of those overall amendments and provisions, we're also adding language to other areas of each individual plan stating variance policies are an option now based on 40 CFR in each of those plans. So both processes are running concurrently, and it's going to be part of one giant staff report. It's going to include both parts, but this particular process is not going to say bacteria specifically.
Thank you.
So just for some quick background, that's because I'm an evil supervisor. But we have been working on we have a number of standards actions going on right now, and every one of them we hit that point where we probably need to identify variance procedures or exception procedures, whether it's mercury, bacteria, toxicity, cadmium, hard. We got a number of things on the plate. So of all those things, it's like, instead of doing this over and over and over again and say, for toxicity, use 40 CFR, for bacteria, use 40 CFR, for mercury, we're doing it once. And again, that's partially because EPA revised the regulations from going to saying that states may have variance policies to saying this is how you do a variance. So EPA went from a very broad statement to a very specific statement in the most recent regulations.
Yeah, so what we're doing is adding the legal language of how to do variance. Every specific variance will need its own scientific background and staff report and work to actually come into play for any specific water body.
Will a variance for a priority pollutant need to also meet the SIP exception criteria, which are different?
I think it depends on.
EPA in their approval of the SIP said that exception said we had to comply with their variance procedures. So, so really, the SIP case-by-case exception is a variance according to EPA, and we have to make the findings of 13110G. And I think EPA, with my discussions with them, any additional quote-unquote case-by-case exceptions done under the state implementation plan would require the same documentation that the variance would, because they are variances. The SIP criteria is pretty consistent with what is required. So what it does is it adds, for the most part, what it would do is state very clearly, which would be required anyway, is that it's subject to CEQA because it's a project.
Any other questions?
Any other questions or clarifications? That's like, you look like you want to ask something.
Hi, I'm Meg. I'm with the Central Sierra Environmental Research Center with Megan Fisk here next to me. I'm just trying to wrap my brain around what exactly is going to be in the draft staff report out in April. Obviously, you just proposed your two alternatives, one being no action and the other being include a variance policy for the statewide plan. So within the draft report, all it will be language on how to develop this variance policy for the whole state and nothing specific about any sort of pollutant, correct?
Right, so
Thank you.
right, it includes, in addition to the bacteria stuff that was previously scoped 2015, the only addition that we're proposing to add to that was outlined in the info doc, and there's copies from the back of the room. You know, just basically a new section F, water quality standards variances, and kind of outlines. It basically summarizes 40 CFR section 131.14 without stating it word by word, but it's basically a summarization of the current federal regulations. So that's all that this piece would propose to add to the actual statewide plans. And the language would be consistent, and although this info doc calls out just the inland surface water enclosed basin estuaries plan, we're also including similar language, if not the exact same language, in the ocean plan as well.
Okay, thank you.
I just, I'll say, for further clarification, so that scoping issue document that you just had in your hand, that, middle section is the only language that is being proposed to be added right now.
Right, it's titled Proposed Variance Policy and starts with subsection F, just that little piece right there. And then also the definition of variance would also be added to the glossary for the specific plan.
Time for lunch yet? Anyway, on San Francisco Bay, as I mentioned, they have a prohibition on any discharge that does not achieve 10-to-1 dilution, which pertains to almost all the stormwater discharges. Would it be possible, since you can have a waterway variance, to designate the San Francisco Bay as having a variance for that 10-to-1 prohibition? Is that something that is separate?
Sorry, the answer Rick was saying was that we believe that to be separate.
Yeah, that's one of their prohibition policies, and we're not touching that. That is not variance. What a variance very simply does is it suspends the water quality standard and says you have to meet the highest attainable use in the interim while you're working towards that standard. So it actually suspends the beneficial use and any criteria that are applicable to that beneficial use. So that's very different from saying that that you're going to limit dilution to 10-to-1 in the San Francisco Bay. That's not a variance at all. It's a policy of their board that would not touch this. So they could adjust their dilution requirements through a basin plan amendment if they wished, but this doesn't touch it because it's a really different thing.
Does a variance policy have a time limit?
Yeah, the term within the variance it just says it's supposed to be the amount of time it takes to meet the standard that you're having a variance from, so that you submit as part of your documentation the term that you believe it'll take as part of the documentation and the steps you're taking to achieve that standards. But there is no time limit within the actual regulation. That being said, the EPA does require within the regs that there is a review of that term every 5 years, consistent with the permit renewal. But it doesn't say it only lasts 5 years. It says you have to review it and make sure what you previously proposed is still correct, and it could be adjusted at that time. Anyone else? Hearing none, I want to thank you all again for making the trip out and talking with us. If you have any additional comments that you come up with when you get home or you talk to somebody, the comment again, which is found in the notice, they can be submitted until February 3rd, and we'll review those. They can be sent to the clerk to the board, and also emailed to comment letters at waterboards.ca.gov, and there's the fax number as well. Just make sure you put in the subject line comment letter, statewide variance provision, scoping comments, so we can get to the right person. Other than that, again, I'd like to say thanks and appreciate your time and the discussion. Have a good day.